Thank you, Your Honor, and may it please the Court. My name is James Parker Flynn. I'm here on behalf of the appellant Palafox LLC, and I would like to reserve 4 minutes of my time.
Would you pull the mic just a little closer to you?
I absolutely can.
Thank you.
This case involves...
How many minutes are you reserving?
4 minutes, Your Honor.
4. Okay, I got it.
Thank you. This case involves one simple issue: whether, once an administrative law judge has made a finding that an attorney has violated Section 120-569-2E by filing a pleading for an improper purpose, whether that administrative law judge can nevertheless determine not to impose any sanction at all. As is made clear by the plain and unambiguous text of that statute, the simple answer to that question is no. Once a violation has been found, the presiding officer shall impose a sanction. In failing to do so here, the administrative law judge not only erred as a matter of law, she also created an incongruous situation where the appellee's counsel was not sanctioned for his improper purpose in filing the pleading, but in a separate order, his client was sanctioned for her improper purpose in the proceeding, which, as was conceded in the answer brief,
So if this was the first time we were looking at this issue, I think you'd be correct, but she cited Mercedes, and Mercedes seems to say that there is a requirement to file your motion in a more timely manner, or you may not get your fees.
Your Honor, we feel that the administrative law judge erred in relying on Mercedes for a couple of reasons. The first is that any language regarding the timing of the motion for fees in Mercedes is actually dicta in that case. This court in that case found that the appellant had not filed his bid protest for an improper purpose. Without an improper purpose, there can be no sanction under the statute in the first instance. So any additional language about the timing of a motion is exactly the kind of additional language that's immaterial to the ultimate outcome of the case, the kind of language that this court has warned, has no binding legal precedent. But I think
would you agree, though, that the motion, at some point, there's got to be an end to it? So, I mean, the motion couldn't be filed 6 months after the final order.
I don't know that the motion could be filed 6 months after the final order. I do think that if we look at Mercedes and the federal sources that it cited, what we see is that it does not say that the motion must be filed close in time to the offending paper. What it says is it must be filed when there is a basis to do so, when that has become discovered. And the cases relied upon by the Mercedes court and also by the appellee in the brief make that very clear. So, for instance, in the case of Inri Yagman, which was cited by the Mercedes court and the appellee, the court there says when a paper is so obviously and recognizably frivolous, we want to see that motion close in time. And that's language paraphrased by the Mercedes court. But Yagman also makes clear that there are many instances when a claim may appear to be genuine on its face, where that claim may even survive summary judgment challenges and only become apparent, or as the Yagman court said, will only be unmasked as unfounded after the evidentiary portion of trial. In the court.
But I think the basis that improper purpose was found was Mr. Braswell had filed all these claims before, and they'd been fully litigated in different cases, and he should have known that bringing him forth again with just a new plaintiff was frivolous or improper.
Your Honor, that was part of the basis of the improper purpose finding. Additionally, the administrative law judge cited to Mr. Braswell's conduct in conducting discovery, or in fact conducting no discovery, and his failure to put on any evidence at the hearing that would have supported those claims. And I think this goes back to that issue from Inri Yagman when we're talking about the difference between obviously and recognizably frivolous papers from other kinds of papers. While Mr. Braswell had raised many of these claims before, his amended petition nevertheless raised a host of highly technical expert issues that, if proven true and if supported by evidence, may have supported a finding that the ERP was not properly issued.
So if there is a timeliness issue, could that not be used to determine what type of sanction is appropriate as opposed to whether or not a sanction is required if there is a finding for improper purpose?
Yes, Your Honor, that is exactly where it comes into play. The statute, again, shall impose an appropriate sanction. It doesn't give discretion to award none, but what these authorities make clear is that in considering any of these outstanding mitigating factors, it's part of the determination of what the appropriate sanction is. And I think it's also important to note that those...
So if we remanded to Judge Van Wyck and directed her to basically figure out what the appropriate amount of fees would have been had y'all filed a motion to dismiss right after the complaint was filed, would that be satisfying to you?
If it was only based on the failure to file a motion to dismiss, no, that would not be for a host of reasons. Because again, as these sources make clear, you don't just look at that. What you really look at is what Judge Schwarzer in the article cited by Mercedes says. Did the moving party have any disproportionate expenses? Did the moving party itself do anything to create unnecessarily lengthy and complex proceedings? And I think the record is abundantly clear here that Palafox did not do that. So first of all, Rule 11, which is all these sources that are relied upon in interpreting 12569 sub 2E, frequently these cases are dealing with protracted civil litigation that lasts years. In this case, it was administrative litigation, which, as this court well knows, moves pretty fast. So between the time of the filing of the amended petition on the last day of October in 2019 through the final hearing in February 2020, 3.5 months had elapsed. That was it. During that time, Palafox retained an expert to evaluate all the claims made in the petition. It relied on the limited written discovery propounded by the Water Management District. It did not issue or serve any additional or duplicative discovery that was unnecessary. It deposed Ms. Diaz herself and their stormwater expert, but not every expert on the expert witness list provided by the appellee, and it presented 2 witnesses at trial. Neither did it engage in any outstanding motion practice to make those proceedings more complex or lengthy. In fact, it filed 3 motions during that 3.5 months. Its unopposed motion to intervene, a motion for official recognition, and a motion designed to keep the proceeding from becoming more lengthy, a protective order where Mr. Braswell sought to call a project engineer as an expert witness, didn't want to pay him an expert witness fee, and also asked him to produce at hearing boxes of files that had not been requested in discovery.
Well, given that you knew all of that before the final hearing, why wasn't the fee motion filed before the final hearing, and why wasn't it mentioned in the pre-hearing, I guess what in trial court you call the pre-trial the pre-hearing stipulation here?
Your Honor, again, as we were going through this process, and again, it's 3.5 months, we have to evaluate a number of highly technical claims made within the amended pleadings. You have to go through all the discovery process first. Once we got to the discovery process, a month before the final hearing, Ms. Diaz was deposed. In her deposition, she says, I don't even know what I'm going to testify to. Mr. Braswell says, we haven't even gotten far enough in our case to know what the testimony is going to be. So it was also important to see, is there any testimony that's going to come out in this hearing that could support that claim? Likewise, Mr. Braswell seemingly intended to rely on the Water Management District's experts through examination to prove his case. He didn't have necessarily fact experts on this. We needed to see, before we file a sanctions motion, whether there's actually any basis for these claims whatsoever.
So is it your contention then that when the ALJ said you needed to identify a concise statement of issues of fact which remain to be litigated, you were somehow able to not file the motion at that time?
Your Honor, I don't think that there's a requirement for a motion for sanctions be filed at that time. I don't think that that was necessarily an issue of fact at that time. Again, it required the full picture, which is reflected in the ALJ's order that she needed to see that full picture before making an improper purpose determination. She needed to see what happened before the pleading was filed. She needed to see what happened during discovery. She needed to see what happened at hearing before she could even make that finding.
As mentioned in Mercedes, and I know you contend it's dicta, but that the purpose of the statute is to avoid this protracted, unnecessary litigation. And certainly, it's been a long time since I've been in federal court, but 57105 has the 21-day time limit that's absent in the 120s. But how does waiting until after the hearing is complete accomplish the purpose then of the statute in the 120s?
Well, I think the court in Yagman, again, makes it clear that even when you have to go through that evidentiary portion of trial before the basis becomes clear, the deterrent purpose of the rule is still served by deterring any future inadequate pleading, not only by the certifying attorney, but by the trial bar in general. And that's exactly what the Yagman court said. That's the purpose of it. I think it's also important to note that in the materials, the Schwarz article, again, relied on by the Mercedes court, these were always things to be considered in the what sanction was available, and Schwarzer reminds that it's not just for deterrent purposes, it's for penal purposes as well. So all of those purposes can be served to ensure that this doesn't happen again. It also should be noted that this, while filed after the final hearing, was still filed before the recommended order came out, was still filed before the final order came out. There was potentially still time, if Mr. Braswell and his client desired to withdraw a claim, they could have done that. They did not do that. So again, what we see from all of these sources, first, the plain text of the statute says you got to impose an appropriate sanction. All of the sources say when you're looking at that, we're looking, did you reasonably respond to these claims? Did you do anything unnecessary to make them worse or disproportionate charges? This court will soon see in a related appeal filed by Mr. Braswell on behalf of his client against the attorney fee award against her, those fees were entirely reasonable.
So this order found an improper purpose on behalf of Ms. Diaz and Mr. Braswell?
No, this order was only directed towards Mr. Braswell.
Okay.
There's an additional supplemental recommended order at page 1095 of the record, in which it found that Ms. Diaz, under 12595, had participated in the proceedings for an improper purpose, a slightly different standard. There's a prevailing party standard there as well. That had to go up on a supplemental recommended order, and then everything beyond that is not in this record. It is in the record of the related appeal for which Mr. Braswell filed his brief on Monday. There's relevant information in there. It's outside the record. I'm happy to discuss it if this court likes, as it's in its files. But the simple fact is the statute requires the imposition of a sanction. The statute makes no mention of the timeliness of a motion.
And you can keep going, but you're into your rebuttal time.
And the administrative law judge erred in failing to impose a sanction as opposed to considering all of the evidence about what the appropriate sanction should be in light of all of the evidence. So for that reason, we would ask that this court reverse and remand with instructions to the ALJ to determine what the appropriate sanction should be. One final note, the appellee spent basically the entirety of the brief arguing that the finding of improper purpose was error in the first instance. The appellee did not cross-appeal on that issue, and this court's precedent makes clear you have to cross-appeal adverse portions of an order. You can't simply raise it for the first time in an answer brief. So those issues are waived for appeal. They are not before this court today, and I will reserve the remainder of my time.
Good morning, Your Honors. I am Jefferson Braswell. I represent the appellee, Carmen Diaz. I guess, should start by saying how seriously I take the issue of sanctions against me. I have worked this case as hard as I know how.
We all understand that.
And I think that the record and the quality of the work, I hope, speaks for itself.
Well, doesn't that go, though, to the improper purpose? And as was pointed out, you didn't cross-appeal that. So that finding you're stuck with, right? No,
Your Honor, I don't agree. I think any time when there's sanctions, if we look at the Mercedes case and the precedents under Rule 11, if I'm being sanctioned, I think this court absolutely has the authority to go review the record and determine that there has been some type of misconduct or something that would warrant the sanctions.
We certainly do if somebody appeals that, but you didn't appeal that.
Well, I think that in a sanctions case like this, that the precedents suggest that this court has the authority to properly evaluate the evidence in total. And so
I'm having a hard time with that, because generally our role is to determine whether issues that are brought before us that are alleged as error on behalf of the lower tribunal, we're supposed to determine whether there was error, but it has to be brought to us. So my understanding is you needed to do a cross appeal, or you're stuck with that finding, and the only thing we're here to argue is whether a sanction should have been imposed or not, and what if any effect of the lack of timeliness of the motion has on the amount of that sanction.
What I can say is first of all, I don't want to spend all my time arguing this point, because I think that there are significant issues related to the timeliness, the strategy of why we're even here, so forth. I do not look at this motion as really being filed in good faith. I think if they wanted to do that, if they wanted to file the motion for sanctions, they knew about this at the time the petition was filed. There is no secret as to what this case is about. This is about the ability of this property owner to fill in 2 acres of stormwater basin, 92,000 cubic feet, and dump it into a conservation easement that it doesn't own. So as far as, why we have filed it, we are here in good faith.
So what about their argument that, there were lots of technical allegations in the complaint that had you been able to bring forth evidence to support them, would have made it a valid complaint and not for an improper purpose. But the fact that you didn't bring forth any evidence or any new evidence that you hadn't brought in any of these other proceedings, that made it improper.
Well, see, I think we're getting right back into the de novo review of the entire process. Look, we presented the evidence that we needed to show they don't have the right. They had to move their case off of the application materials. So there's no place in the application materials where they say this is a water of the state. They completely made that up in the administrative hearing. We forced them to go that direction. And so now they're saying, well, we get to use Ms. Diaz's land because it's part of a water of the state. And that's just simply not the law. The rules of the Water Management District clearly require that proper authorization and ownership is there.
You're arguing the underlying case, and I think we're just here on I know for sure we're just here on the issue of fees.
Well, I just want this court to understand that issue is
your
valid.
argument that I should have won on the merits of this is not something that we really can take up.
It applies to the position of sanctions, though. If this court does a de novo review and looks at the record and determines that our case is valid, that they really do not have the authorization, that their wetland delineation really was 17 years old, that the statute doesn't permit it to go forward. If you look at those, then this court should be satisfied that our case is valid, that we are correct.
Can I ask you a question about timeliness? How do you respond to Palafox's argument that Judge Ray mentioned that the delay in filing the sanctions motion perhaps goes to the amount of fees that should be awarded, but given that there's no time limits in the statute, there's no specific timing on when the fee motion must be filed?
Yes, Your Honor. The Mercedes case, which is well-established 1991 precedent in the First District Court of Appeals, makes it clear that there's a procedure and a process that people have to go through in order to make their claim for fees. One of the things that we cited to was the Wilson recommended order out of DOA, where Judge Alexander goes through a long list of cases that are at DOA where they come in just prior to the hearing, or they come in at the hearing. And in each one of these, this is at page 40 of that decision, there's at least 5 or 6 examples.
And these are DOA cases?
These are DOA cases.
Okay.
So these are, well, there's no real precedent other than Mercedes in this court. So I think we've got to go and look at what DOA has done over the years.
And that's persuasive. I mean,
And hopefully it is. I understand that it's limited,
Yeah.
but it should be persuasive. And in each of those cases where the petitioner for the fees comes in and does it at the opening of or after the proposed recommended order, each one of those is rejected as not being timely. And it's because of this nexus with Rule 11, the federal rule, where the precedent is long-standing that if you want fees, you got to plead them. And now, I make the argument, I'm much more of a civil practitioner these days, but even in Stockman Downs, even in the Supreme Court.
That's clear under Rule 11, right?
Right.
It's clear, okay.
So you're going to make this claim, you don't wait until, and lay in wait, and sucker punch your opponent. And that's exactly what I'm dealing with here, is that they waited until their proposed recommended order. Now, keep in mind that our response was, we withdrew the petition, settled with the Water Management District, we had what we wanted, which was the record, We have their decision. We know they're using our land inappropriately. We know that they don't have the right. We got what we wanted. We settled. And if we offered, we wanted to settle with them too. But they wanted to go forward with this claim that they dropped on us at the proposed after we had already filed ours. So there was no way for us to respond. There was nothing that we could do.
Well,
And this is part of the strategy, is to trap us into this and separate me and sanction me and separate me from my client.
Well, and the ALJ seemed to agree with you in ruling that, the motion wasn't timely filed. But she had an order that's somewhat confusing to me. Order on issues for post-hearing submissions, which is 214 in the record, where she said, to clarify for the parties the issue of timeliness of petitioner's renewed petition for attorney's fees and sanctions is not cognizable in this proceeding and should not be addressed in the proposed final orders. But then she addressed timeliness. What does that mean? Does that have any impact on what we're doing here?
Yes, the ALJ has a lot of confusion, and I think you'll see it perhaps more in our appeal that was just filed on Monday. But I'm not sure I really understood where she was going, but I did understand it sufficiently to say you can't argue that point I don't want to hear it. And so I think we were left with no other alternative but to comply with what she said. I'm not sure.
But then you won on timeliness anyway, so did that language that she had there matter? Is there anything?
Well, yeah, I think it should show this court kind of the sporadic nature of this whole process at the end. I mean, on the first day of the hearing, we got into counsel for the appellant trying to introduce the other recommended orders and other things into evidence, and the ALJ said, no, we're not subject to stare decisis here. We're not subject to those opinions, and so I can take them and consider them, but I'm not bound by the Leon County ruling. We've got to go through our own process, and that's really what I would say here is that, the fact that there are two proceedings, the Leon County Planning and Zoning, which is all subject to the Snyder case, where this Florida Supreme Court goes into the county commission. I understand it was tried at DOA, but that's unique to Leon County. And then we have the 12057-1 proceeding, which is an administrative process going in front of the Water Management District, arguably not quasi-judicial, because there's not supposed to be any politicians over there. And so when we go forward on our presentation, a scientific presentation, we're supposed to have a better audience. They have their own rules. So council likes to argue, oh, well, you should have known that it was going to be the same result. But there's a whole body of rules, and especially those dealing with the authorization and so forth. So when we go forward on these matters, we go forward in good faith. In fact, I would suggest that I'm right. I mean, I think it's clear. Now, we didn't take this case up on appeal, and we have legitimate reasons for doing so. We believe our best case lies with private contracts, developers agreements, the conservation easement, because they're using a conservation easement now as a stormwater basin. So the deeds to the property, which provide no easement. So we think that our strategy is legitimate and sound, that we have acted appropriately when somebody's coming in and trying to take your property and dump all their stormwater on your land. We think that we have proven that. I think that the findings of fact will show that they are increasing the amount of water by 0.384 inches on Ms. Diaz's property, and they don't have the right to do so. And so when we go in and look at the issue of sanctions, it's clear that, for one, that the appellant was required to identify the offending pleading. And the statute, 120.569, requires a signature on a particular document. Now, none of that has been identified in this case. So we get into the pre-hearing stipulation. And so what happens with the pre-hearing stipulation is we're supposed to identify the facts in the law. We go all the way through the process, and they remain completely silent. And then the pre-hearing order suggests that, hey, if you fail to include an issue like attorney's fees, I'm not going to consider this. So again, it's just kind of a sucker punch at the end of the case to pull us into this court proceeding. So again, the Mercedes case goes on and talks about these issues. And I think it's important that the appellant's counsel put his name and signed the agreement in accordance with that pretrial order to suggest that, hey, I agree that these are all the issues. So to come back after the hearing and claim that circumstances have changed after the petition is basically the same as it was, we had, of course, had to go directly to the Water Management District rules and regulations. We had to go and identify what was at issue there. We hired an expert, and they like to try and say, oh, that I prepared the report, which is fundamentally not true. The report never even came into evidence. So a lot of these things are just not appropriate. So let me say one last thing. It's taken a lot of courage to take on this case. And, the party, the developer is very powerful. Carlton Fields is very powerful. I'm not from Tallahassee. So the whole circumstance has really been challenging. It's created a lot of angst and injury. And so I look at myself and I'm like, no, you got to do this, because you can't just stand by and let somebody take somebody else's land. It's clearly wrong. And so, but this is not relevant necessarily to the facts. The fact is that the government has given this developer approval to completely remove and fill 93,000 cubic feet of stormwater in the retention basin and change it to detention with filtration effectively. All the water ends up on my client's property.
Mr. Braswell?
I understand.
You're done with your time, so briefly sum it up.
This case is about Ms. Diaz's right to stand up against the government and against the developer and against Carlton Fields and say, you can't have my land. You can't use it for your stormwater storage. You can't alter my plat.
Thank you, Mr. Braswell.
Thank you, Your Honor. Just a couple quick points here. First, Mr. Braswell referred to the nexus with Rule 11. You asked about that as well. I think it is worth pointing out that Rule 11 was amended in 1993 to expressly give courts the discretion whether or not to impose a sanction in the first instance. It used to have the same shall impose standard that 12569 sub 2E has. Our statute has never been changed. It remains the same. Likewise, I think it's important to also note that the Donaldson case cited by the appellee in his brief and by the Mercedes court notes that Rule 11 itself is notice of a potential sanction. Every practitioner should know that attorney's fees are out there if you file a pleading for an improper purpose. The same is true in administrative practice here in Florida. Every attorney should know that 12569 sub 2E is out there. Judge Roberts, as to some of your questions regarding the motion to dismiss, I think it's also important to note that these resources relied upon by Mercedes talk about the ability to potentially resolve a claim earlier on summary disposition. That's not really an option when there's a recommended order authority that the judge has. 28-106-204 of the Florida Administrative Code authorizes motions for summary final order in cases where there's final order authority, no such authorization for summary disposition of recommended orders. Occasionally, they are filed, but on almost all events, they're deferred to the end of the hearing in any event because the litigant has a right to present all of their evidence under the Administrative Procedures Act. And a motion to dismiss simply does not provide that same thing. It's limited to the four corners of the pleading. You can't go outside of it to show anything that happened before the pleading or any of the evidence that's adduced at trial or through discovery. It's simply not an option, particularly when there are highly technical allegations made within the complaint. Again, we never alleged that this amended pleading was so obviously and recognizably frivolous on its face that it warranted sanctions. Neither did the administrative law judge. It was all of the circumstantial evidence which the court and the administrative law judge are allowed to consider under this court's precedent in determining an improper purpose. So again, simply put, a motion to dismiss would not have sufficed here. There was no procedure for summary disposition, and there is no requirement in any of these statutes or cases that have been cited that says you have to do this early in time to the offending paper. There are times where it comes out later. You have that right. And additionally, it goes to what the sanction should be in any event. What did you do? Were your expenses reasonable? Palafox
Let me
is
ask
quite...
you a question, I guess just jumping off on a hypothetical Judge Bilbrey mentioned earlier.
Yes, Your
What
Honor.
if the motion was filed 6 months after the proceeding ended? Certainly there's no express timeliness requirement in the rule, but what type of sanction would be appropriate even in that case?
Your Honor, it's hard for me to speculate about what kind of sanction would be appropriate in that scenario. I've not seen a case that specifically addresses that, and certainly nothing in any of these materials discusses anything like that. They simply say that there are times that you'd still need to go through the evidentiary portions of trial, and so that is what happened here, and that's why it was needed and why we would ask this court to reverse and remand with instructions to impose an appropriate sanction. Thank you.
All right, thank you both for your argument.